Hi, I'm firearms attorney Gilbert Ambler, and we are back to talk about the brace pistol issue once again. And the reason we're back to talk about it right now is we are getting into mid-May, which means the May 31st deadline to come into compliance with the ATF's new rule is fast approaching. And as of the time of filming this video, no one has issued an injunction against this rule just yet. Now, of course, there is still a chance. There are still lawsuits that are asking for an injunction that have not yet had that request ruled on, so that there is still a possibility that a judge will issue an injunction prior to May 31st and stop the enforcement of this rule. The folks I'm talking to today, however, are those folks who said, well, I am going to wait, understanding that I have until May 31st to come into compliance with the rule. I am going to wait until mid-May to do something, to make a decision. And now we're arriving at mid-May, so decision time for those folks is coming. And many of them said, if a judge hasn't issued an injunction by May 31st, I'm going to go ahead and I'm going to register my brace pistol. I'm going to take advantage of the tax exempt or the tax amnesty Form 1, and I'm going to get this thing registered. That way I am in compliance. Those are the folks we need to talk to today, because we're going to talk about the risks with that approach, as well as how we could best mitigate these risks. Now, before we dive into this, if you have not yet hit that subscribe button, go ahead, hit subscribe, like this, comment, share, tell your friends. That way you and your friends can keep getting this pro-Second Amendment related content. All right, let's start out with the idea that in mid-May of 2023, we're in possession of a brace pistol, and because there has not been an injunction granted on this issue yet, we're going to register it as a SBR tax-free to come into compliance with the ATF's rule. And we understand further that the ATF has told us that although they consider this item in our possession to be an SBR, a short-barreled rifle, as it currently sits, albeit an unregistered SBR right now, that as long as we have submitted a properly completed application by May 31st for this item, we can remain in possession of the braced pistol, which is not yet registered until we get approval back, even though it might go past May 31st. That means if you submit your application on, say, May 29th or May 30th, it might take a couple weeks or even longer to get an answer back from the ATF, and as long as it's a properly completed application, ATF says that's okay. However, I think that there are some major risks involved with this approach. The risk I see is this. What happens if you submit your Form 1 mid to end May, don't get an answer by May 31st, and so you decide, well, ATF said I can remain in possession of this because I submitted a properly completed application, but then sometime in June or even July, you get a denial back from the ATF. And this happens, and I know people think this isn't going to happen to me, but it might happen because we see denials for all sorts of clerical issues. I regularly talk to folks who get denied for either clerical issues with how they submitted their application, or because even though they've been buying guns for years, the ATF and the FBI saw something in the background check that they didn't like, and therefore they issued a non-approval or even a denial. What if you're one of these folks? Because if you're in that situation, what will have happened is you are still in possession of an unregistered SBR after May 31st because you thought you were going to get an approval, and in fact you got a denial or a return without action. If you're in that boat, now we are very worried that the ATF might prosecute you for possession of an unregistered SBR. That's a federal felony punishable by up to 10 years in prison. So how can we mitigate this risk? And before we dive into mitigation, I just want to head off a couple of things that I know I'm going to see in the comments, because some folks are going to say in the comments, well, Gilbert, the ATF doesn't have the manpower to track down all of these people that get disapproved. Well, maybe, maybe not. We're seeing them start to go after the forced reset triggers showing up at people's houses. So who's to say they wouldn't show up for someone who had submitted a Form 1 for a brace pistol and then got a disapproval? I think that's very possible. Other folks are going to say, well, Gilbert, you must not know the law at all, because there's statutes out there that say that the information you provide on the Form 1 up to and concurrent with the time of filing can't be used against you. And I agree to the extent that those statutes say that information can't be used against you as evidence. At least one federal court, however, has already ruled that they can take the information received on that application and use it as a basis to go gather more evidence. What would that mean? It means you supplied the ATF with a Form 1, which indicates you have a brace pistol that you want to register. It gets past May 31st, therefore you're past the grace period for the rule, and then ATF disapproves you. At that point, I don't see what would stop them from obtaining a warrant and showing up at your home to search your home and try to find this brace pistol turned SBR and then prosecute you for its possession. I think that is a legal possibility. So how do we mitigate this risk? My advice, if you're going to go down this road, you think that you're going to register your brace pistol, take advantage of this rule, and you're submitting your registration or your request at this time here in mid to late May, my advice to you is after you submit your properly completed application is to take the brace off of the weapon and get the brace and any other stocks that you might have that are not affixed to other rifles in your possession out of your possession. Give them to a friend, give them to a neighbor, give them to someone that doesn't have any weapons that they fit on. Why would we do this? Well, the reason we would do this is because if, God forbid, there's a clerical error and we get denied or disapproved on our Form 1 application, and that denial or disapproval happens in June, July, or even later in August, for example, and ATF were to show up at our house at the time of the disapproval with a search warrant, looking for further evidence to use against you to demonstrate that you're in possession of an SBR, a brace pistol, after the 31st, well, we are going to take away their ability to actually find a brace pistol or unregistered SBR in our possession. Because when they execute that search warrant, what they will find is they will find a pistol, they won't find any braces that would fit on the pistol. Why? Because you gave the braces to a friend, a neighbor, a relative. And of course, once you get the approval back, if you do get approved, you could go collect and ask the friend, neighbor, or relative for the brace back, and then you could reinstall it. Now, is this a absolute fix to all of the legal concerns? No, it's not an absolute fix. I mean, there are still possible things that could go wrong for you, right? ATF, when they serve their search warrant, they might find other weapons violations. That's possible. ATF might argue that when they served that search warrant, because when you submitted the Form 1, you were acknowledging that you had a brace pistol. When they showed up, they didn't find any brace pistols. They might argue some type of perjury related charge. Now, I think you could defeat that charge because at the time you applied, you did in fact have a brace pistol. But the concern is, are there other things you could be arrested for? Sure. What are we mitigating here? We're mitigating the risk that you get arrested for possession of an unregistered short-barreled rifle if you get a disapproval or a return without action or something other than an approval after May 31st. And I know this is a bit complicated, but it's an important subject and it's an important thing for people to mitigate their risk on, because I don't want to see anyone get arrested for a violation of this rule because it is such a silly rule. All right. Final point out there. If you take this advice, or if you don't take this advice, if at any point ATF ever shows up at your house and wants to ask you questions, the only proper answer, because we're seeing some of these videos circulate online, the only proper answer in return to these questions is, I'm not making any statements without a lawyer. I'm not answering any questions without a lawyer. Just keep repeating that until the ATF goes away or until they do what they're otherwise planning to do. If they show up with a search warrant, you do not consent to any searches, okay? They're going to come in if they've got a search warrant. You're not going to stop them. You're not going to obstruct. You're not going to prevent them from coming in, but you don't have to help them. You don't have to open up locked safes. You don't have to do anything to assist them. Are they going to cut those safes open? Absolutely they are. Why are we not helping them by opening these safes? Well, we're taking away an argument that we in fact did consent. Because if down the road it turns out their warrant was an unlawful warrant, now you're giving the lawyers legal grounds to contest what they found in that search. All right? If you've got questions about this, go ahead, reach out to us. We're happy to try to address those questions. Until next time, stay safe, and remember, like, comment, subscribe, tell us what you thought of this video.